Music in the background is that coming through from Thai rock group Bathi Begezela Yes Noma Kunzima, just past 10 minutes after the hour, 5 o'clock. Good afternoon to you. Welcome to the Maranatha Drive right here on your favorite Christian radio station. It's time to go into our final conversation. Life Matters, we call it, and we are looking this afternoon on parental leave. It's a legal matter, so do join us as we converse together. We're not going to be alone. We have our legal expert joining us this afternoon, so do come through.
You are tuned to Maranatha Drive on Adventist World Radio, powered by SID Media.
Certainly, that's where you're at, Adventist World Radio, SID Media. And this afternoon, as we go through our Life Matters segment here on the Maranatha Drive, we are going to be looking at parental leave. It's a legal matter now following a landmark ruling by South Africa's Constitutional Court. Just this month, October 2025, the country's parental leave laws have been fundamentally reshaped to ensure gender equality. You see, the transformative decision now guarantees a shared part of 4 months and 10 days of parental leave for both parents to divide. And Sindiso Sibanda, partner and director at MSM Associates, will be joining us this afternoon to discuss the implications of this ruling and what it means for those who are citizens and practicing their lives, their citizenry in South Africa. Good afternoon to you, Mr. Sibanda, and thank you so much for joining us this afternoon.
Thank you so much, Derek, and good afternoon to you and your listeners.
Thank you so much. Trusting that we find you well, and it's been a good Thursday.
I am very well, and it is indeed a good Thursday.
Wonderful stuff. Thank you so much again for coming through. And we are looking at this legal matter today, parental leave, which has been apparently reshaped, as we were saying there in our introduction. What are the key discriminatory aspects of the old parental leave laws that the Constitutional Court now had to address in its recent ruling?
Right. The Constitutional Court was tasked with the decision of, determining the constitutionality of two aspects in one, the Basic Conditions of Employment Act, as well as the Unemployment Insurance Fund Act.
Okay.
Now, basically, it looked at the issue of obviously the treatment of birth mothers, whom it was said that the treatment of birth mothers was differentiated from the treatment of non-birthing mothers as well as fathers. Now, as well as adoptive parents. So basically, what the Constitutional Court found, it found that indeed the treatment of birth mothers was different as compared to that of fathers and adoptive parents. It created a category of parenthood that differentiated between three types of parents, mainly the birth mother, the father, as well as an adoptive or surrogate type of relationship. And this also created different types of leave entitlement, which the court was of the view that it amounted to unfair discrimination, and obviously on the grounds of gender, as well as parental status and family formation. The court also found that the act as it stood, or the leave regime as it stood,
Yeah.
created an arbitrary age cap in
Mm.
relation to adoptive children. In other words, basically, what it created was a differentiation between children who were below the age of 2 and children who were above the age of 2,
Okay.
during a situation where those kids are adopted. Now, obviously, during that adoptive process, it meant that the leave that was allocated to a parent who is adopting a child above the age of 2 would be
Hmm.
less than a parent who is adopting a child that is below the age of 2. And
Mm.
also, the old framework presumed that the biological mother was the primary caregiver, which
Okay.
naturally sometimes is not
True.
always the case, because
True.
there would be, as we've indicated, other types of parental.
Parenting
Um,
models. Yeah.
exactly. Now, this is a situation that the court was faced with. And what the Constitutional Court found in relation to that is that that type of regime reinforces gender caregiving roles, and it undermines the dignity and equality of non-birthing parents.
Mm.
And because of
Mm.
these differences, the leave scheme was obviously in totality found to be inconsistent with the rights to equality and the right to dignity in terms of the Constitution under Section 10 of the Constitution.
Okay. Okay. No, thank you so much for that. I think really, really pointing out what were the issues there. So, as we now look at the law today after the amendment, what are the key or immediate changes that employers need to be aware of, or that employees or parents who are going to be needing to apply for this leave, what do they need to be aware of? What are those changes that have come through?
Now, in relation to the changes, although Parliament still needs to amend the laws, the courts
Okay.
have ordered interim changes to be read in to the
Hmm.
current regime. In other words,
Hmm.
they must be applied immediately. So,
Okay.
basically, now what needs to happen is that all parents are now covered under a unified parental leave regime
Hmm. Hmm.
that does not separate between the maternity, paternity, or adoptive parent type of bracket.
Hmm.
Um, where only one parent is employed, or there's only one parent who is employed, who has that parental relationship, that parent is entitled to the full 4 months
Okay.
maternity leave.
Okay.
Where both parents are employed, the parents are collectively entitled to the total 4 months plus 10 days of parental leave. And take note, Derek, that we
Hmm.
now refer to it as parental leave and
Not
not maternity leave
maternity.
in this case.
Yes. Yes. I picked that up.
Right,
Yes. Hmm.
exactly. Now, if the parents cannot agree on how to divide or share the leave,
Hmm.
the default position is that the leave would be split as closely as possible to a half between
Hmm.
the parties.
Okay.
Now, it is also important to note that the traditional 6 weeks post birth for mothers to recover remains untouched. So, in other words,
Okay.
a
Okay.
birthing mother is still entitled to that 6 weeks post birth recovery period.
Hmm.
But it also constitutes, or it also forms part of the total entitlement in relation to the leave days that are allocated. So in this case, employers need to update their internal leave policies and handbooks, obviously, employment contracts, and forms to reflect the new shared gender entitlement regime that is currently now in place.
Mm.
And these interim changes, obviously, would need to be in effect immediately until Parliament then brings it in line with the current judgment that has found it to be discriminatory, and that would be a period of about 36 months.
Yeah, yeah. I want to just understand what you spoke about earlier, and maybe help us clarify with Cindy. You said that the birthing mother is still entitled to the 6 weeks, right? Is that forming part of the 4 months 10 days? In other words, what I'm trying to say is, if perhaps they then decide to split it in the middle, 2 months 5 days, 2 months 5 days, that this one will have technically 2 months 5 days, including the 6 weeks, or the 6 weeks on top of the 2 months 5 days.
Right. So the 6 weeks forms part of the total entitlement. In other words, it
So of the
forms
4
part
months,
of 4 months plus
10
10 days.
days. Okay.
And it is not negotiable. In other words, even in dividing, which is why when I referred to the split, I
The
said it is
splitting.
as closely as possible
Yes.
to
Yes.
half.
Okay. 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 So the half will not be necessarily 2 months, 5 days. It will be half of what then is the balance of that. Okay.
Exactly. That
Okay.
would be how it would be calculated.
What would you then say is the most critical first steps that employers at this moment need to take to ensure that the internal leave policies are compliant with this new ruling?
Right. Employers now need to get into a system where they update all their internal parental leave policies. Anything that is related to documentation, forms, must reflect the new interim shared parental leave changes. So the employer must revise their HR policies, their leave handbooks, their employment contracts, and their forms. And
Okay.
the forms that previously referred to maternity leave must now be changed, obviously to reflect that it's parental leave as opposed to maternity leave.
Mm.
They must add a process for the employees to submit their election if they've elected to divide the days, how they've elected to divide the days, and this must be done obviously by the employees in advance.
Okay.
The employers must also ensure that managers or payroll or HR are briefed on the changes and the types of leave regimes that the employees would have elected. So
Mm.
obviously, this would include training or retraining for HR
Yes.
practitioners,
Hmm.
managers, and all those who are responsible, obviously,
Yes.
in deciding how to allocate leave, so that they are capacitated in relation to this particular issue. And then
Hmm.
employers must also there's certain employers, Derek, at times who offer paid maternity leave. Maternity leave previously
Hmm.
um, would not be it would not be paid. You would claim from the UIF. But there
Okay.
are some employers who, as a benefit, offer paid maternity or used to offer paid
Paid
maternity leave.
maternity. Okay.
In this case, now because it is parental leave, if the employer offers paid parental leave,
Hmm.
that must apply to all employees, whether they are fathers or mothers in this case.
Mm. Mm.
Right. And
Okay.
and finally, the employers must also flag their policies to reflect that these changes are interim in nature and will be changed once Parliament has changed the laws and has made updates to the law.
Thank you so much for that. I wanted to find out two things. Let's start with this one here. Um, when you talk about this shared leave and then applying for it, obviously the majority of people who are going to be applying are not working in the same company. How will the HR of company A, where the one spouse is working, or the one parent, let me put it rather that way, is working, be able to then corroborate that what this spouse has put here is collaborating with what the other spouse and the company B has put up for their leave? I'm just trying to avoid a situation where people then, because I'm seeing a blind spot, and maybe you can help us what they have done to rectify that I won't take 3 months leave and my spouse will take 3 months leave, and we have 6 months quote unquote total leave instead of the mandated 4 months of 10 days. What has been put as a measure to regulate that?
Okay. Very interesting question, Derek. And obviously this will come with operational issues.
Okay.
How the communication is done would obviously be done by the employer, and this is why the election must be done in advance.
Okay.
The election of how you're going to conduct. So, for instance, maybe at onboarding of an employee, you're already asked how you are going to, how you're going to split your parental leave.
Parental leave, yes.
And the other parent would also have to make an election, obviously, of how they are also going to be entitled to that parental leave.
Yeah. And I think that's going to be quite a fascinating one. I actually was seeing that it was a question that one of our listeners on our WhatsApp line was also
Most
asking, to say, hey, how do we do that? Because in fact, they are wanting to take the whole 4 months, 10 days for themselves, and their husband must also take another 4 months.
4 months and 10 days. Most definitely. And look, as the changes obviously come into place, we are going to find a few snags here and there.
True.
And those would be ironed out as as time goes on. This would come with its own problems, obviously, and those are some of the problems that would need to be ironed out.
Sorted out.
Obviously, there needs to be employer collaboration between the
two companies,
two spouses, employees, so that they know that, oh, okay, this person has elected this person has elected this, and so on and so forth. So there needs to be collaboration also between employers.
Certainly, and I think I must say I was a bit disappointed when I heard this, because when the news came out, obviously with misinformation, people thought that no, husbands can now also get 4 months, and people were quite excited that, okay, so we're going to be having 4 months together at home, trying to take care of this little newborn or newcomer to the home and so forth. But actually, no, it's not that you're both getting 4 months; it's that you're both able to share the 4 months that were already available. And I think people were kind of disappointed, like, come on. But I guess sorry.
An interesting thought came to my mind. I'm thinking of situations where one is in a polygamous relationship and so on and so forth. That would be an interesting scenario.
That is true. That is true. Now, my second question that I had pointed out earlier on, I wanted to find out, the wording of this new amendment, changing, of course, from maternity to parental, because it's not just about the maternal parent. When you look at it, parental leave, is it then just limiting it to this form of parenting where the newcomer comes into the home either by birth or, like you said, by adoption? Or are we also, because I'm just trying to find out how you differentiate it now to personal responsibility leave. It won't be confused for the two?
Not not necessarily. Remember,
Mhm.
one of the things that the court found was problematic, and I mean, just excuse me, Derek, for the people who are watching, my
Mhm.
lights go off
Or when there's no
automatically.
movement.
So when there's no movement, so I just need to move slightly to get the lights to. Uh,
There we go. Okay.
right.
Mhm.
Um, so remember we spoke about the different types of parents, and
Yes.
we
Yes.
said that there's the birthing parent who is the mother, and then
Mhm.
there is the father, and then there's the adoptive parent.
Parent. Yes.
So that needs to be taken into consideration. And if I'm understanding your question, is it confined to this type, as in where there is a birthing mother? No, it is not confined to a situation where there's a birthing mother, but
Mhm.
it encompasses all types of situations where a new little human being comes
Is coming in.
into. So whether it is adoptive, um,
Mhm.
adopting a child over the age of 2 or below the age of 2, surrogacy as well,
Mhm.
where the child is born out of a surrogacy arrangement, that is also
Mhm.
taken into account.
Yeah, my question was actually beyond that, to say when as a parent, because when you say it's parental leave, one might then say, no, my child is sick today. They need to go to the doctors. I need to take leave. It's what is usually called personal responsibility or family responsibility leave. But here you are taking it as a parent. I'm just looking at the wording of the new amendment.
The,
It's
the,
parental
the
leave. Uh,
phrasing.
yes, yes.
Great. Nice pick. Nice pick. Now, the phrasing parental leave, that change simply replaces the phrasing of maternity.
Maternal. Okay.
Right.
Okay.
So it is linked to a situation where there is a little human being that comes
Comes into the
into the
family.
world, one or
Okay.
comes into the family one way or the other.
Mhm.
It is distinguished from family responsibility leave, which
Okay.
you would take, for instance, when after you've exhausted the parental leave,
Mhm.
and the little bundle of joy gets sick or something of that nature, then you have to
Yeah.
take family responsibility leave for that. One other distinguishing factor, obviously, is that
Mhm.
the entitlement to this particular leave must be within 4 months of the birth or the adoption of the child.
Okay. Okay.
So it cannot be
Okay.
beyond
Mm. Mm. So you can't pick and choose when you then take it. It has to be within this time frame where
within
we
4 months. Yes.
makes sense. Makes sense. Maybe as we close off, then, thank you so much for that, Butsindi. So, as we close off, we were talking about employers who now need to adjust their current laws and regulations in the HR departments. Should they fail to put these things into place, what could be the consequences that they will face?
Look, if employers fail to put these things in place, they risk a number of things. One of
Okay.
the situations that they get themselves into
Hmm.
is the failure to comply with the constitutional charter. And this obviously it brings about risk of reputational damage. You risk scrutiny by employee agencies and so on and so forth. You risk litigation in areas of unfair discrimination. And in this case, the Constitutional Court has already made a determination that the previous regime was discriminatory. Now, you don't want to find yourself in a situation where you are faced with a case where one would call it a slam dunk case against you, because the courts have already pronounced on the issues of unfair discrimination in this case. And also, they risk violating the employee's rights to dignity and the employee's rights to fair treatment and so on and so forth. And finally, they also risk enforcement of scrutiny in relation to enforcement of regulations.
Okay.
So labor inspectors or tribunals may look into the company and its leave policies to determine how they are treating their employees. And also employees may say, okay, I intended to take leave at a certain time and I was not given leave, and then they have potential retrospective claims against them.
Yeah, so I guess in a short way, you're just saying, as an employer, you want to find yourself really being compliant in this regard to avoid major issues. Yeah. Well, thank you so much, Baba Sibanda, for your time this afternoon. Any final thoughts you'd want to leave with the listener, the viewer this evening regarding this very, very new bill that's coming in, the amendment to the maternal leave, which is now titled, Parental Leave, right?
Well, generally, Derek, final thoughts is these are obviously immediate changes. These are changes that need to be effected immediately. We cannot wait for them to be implemented. And employers and employees can, as of now, start utilizing this. So if you're a parent and you're expecting a child, this is the time when you need to start thinking about how you're going to allocate leave, how you're going to share the leave between yourself and your partner or your husband, because there's the critical issues that one needs to take into consideration and thought must put into how these things are going to be done.
Certainly. Thank you so much. I think a very, very profound information you're sharing with us right there. And thank you once again for spending the time to educate us and to just help us be more aware with what's the responsibility and what we're needing to be doing in our spaces. Once again, may God bless you. Until we chat again next time.
Thank you so much, Derek. God bless you too.
Wonderful. Thank you. That's Mr. Sindiso Sibanda joining us this afternoon as a legal practitioner, helping us make sense of this new bill that's just coming in, parental leave. Do you know it? Are you aware of what it's all about? Why don't you take a listen again to that podcast and maybe get yourself educated? It has quite some serious consequences that you need to find yourself, especially if you're coming in from the employer end.
You are tuned to Maranatha Drive on Adventist World Radio, powered by SID Media.